Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only. The information provided regarding American legal history, historical trends, and case studies does not constitute legal advice, financial advice, or professional counseling. Every legal situation is unique and governed by specific state statutes and individual circumstances. You should conduct your own due diligence and consult with a qualified attorney licensed in your jurisdiction before making any decisions related to matrimonial law or domestic relations. The historical data and outcomes discussed are intended to provide context and are not indicative of results in any specific modern case. There was a time in American history when a man could lose his entire social standing, his property, and his access to his children not because he had committed a crime, but because the law viewed him as the sole moral and financial guarantor of the family unit. Imagine a legal system so rigid that for nearly 2 centuries, a divorce could only be granted if one party was proven to be a villain and the other a saint. If both people wanted out, the law actually barred them from leaving. This is the hidden history of the American divorce court, a system that was originally designed to protect the sanctity of the home, but ended up creating a complex web of precedents that still dictate the potential outcomes for men in family courts across the United States today. Most men entering a courtroom in 2026 believe they are dealing with modern rules, but in reality, they are fighting against legal ghosts that are over 200 years old. In this deep dive masterclass, we are peeling back the layers of American legal history to understand exactly how the male experience in divorce has evolved. We will explore the transition from the era of legislative divorce, where you literally had to petition the state government for permission to separate, to the rise of the tender years doctrine, which fundamentally altered child custody, and finally to the seismic shift of the no-fault revolution. This is not just a history lesson. This is a roadmap to understanding the systemic mechanics of the American legal system. By the end of this series, you will understand the historical trends that shape modern alimony, the case studies that define parental rights, and why the head and master laws of the 19th century were replaced by a framework that many find just as challenging to navigate today. This is the knowledge that helps you see the why behind the how of the American legal process. To understand the current state of domestic relations, we must first look at the colonial and early republic periods. In the late 1700s, divorce was not a judicial matter. It was a legislative one. This meant that if a man in Virginia or New York wanted to dissolve his marriage, he couldn't just hire a lawyer and go to a local courthouse. He had to have a bill introduced in the state legislature. This process was intentionally designed to be prohibitively expensive and socially devastating. The historical data suggests that during this era, divorces were so rare that they were often front-page news in local gazettes. The legal theory of the time was rooted in coverture, a doctrine brought over from English common law. Under coverture, a husband and wife were considered one legal person, and that person was the husband. While this gave men control over property, it also saddled them with absolute, lifelong liability for their wife's debts and conduct. If the marriage failed, the man remained financially tethered to the woman indefinitely, as the legal identity of the wife was subsumed by his own. As we move into the 19th century, the shift from legislative to judicial divorce began. This is where we see the birth of fault-based divorce. This era introduced a high-stakes legal theater where men had to prove grounds, such as adultery, desertion, or extreme cruelty. The potential outcomes of these cases were binary. You were either the innocent party or the guilty party. If a man was found to be at fault, the legal consequences were draconian. He could be stripped of his assets and barred from ever seeing his children again, as he was deemed morally unfit for the duties of a citizen. However, a fascinating historical trend during this time was the rise of divorce mills in states like Indiana and later South Dakota. These were jurisdictions that lowered the residency requirements and expanded the list of faults to include things like habitual drunkenness or failure to provide. Men would travel hundreds of miles to spend 6 months in a frontier town just to gain access to a more lenient court, a precursor to the forum shopping we see in modern high-stakes litigation. One of the most critical turning points for men in this history is the emergence of the tender years doctrine in the mid-1800s. Prior to this, under common law, fathers almost always received custody of children because children were viewed as an economic asset and the father was the legal provider. But as the Industrial Revolution moved men out of the home and into factories, the legal system underwent a radical shift. Judges began to adopt the idea that children of tender years, typically those under the age of 7, required the nurturing care of a mother above all else. This was a direct departure from centuries of precedent. Case studies from this era show a rapid decline in paternal custody awards. This doctrine created a legal presumption that would dominate the American court system for over a century, fundamentally changing the expectations and potential outcomes for fathers in every state in the Union. Understanding this shift is vital because, although the tender years doctrine has been officially replaced by the best interests of the child standard, many legal scholars argue that the cultural residue of this 19th century shift still influences judicial discretion today. As we progress through this masterclass, we will also examine the economic evolution of the alimony system. Originally, alimony was not a post-divorce payment in the way we think of it now. It was a continuation of the husband's duty to support his wife because legally, the marriage had not fully ended in the eyes of the church or the state. We will look at how the shift from an agrarian economy to a wage-based economy in the early 1900s transformed alimony from a localized duty into a quantifiable, long-term financial obligation that could be enforced across state lines. We will analyze the data regarding how these support orders were calculated before the advent of modern software and standardized guidelines, often leaving men at the mercy of a single judge's personal views on manly duty and provider status. This deep dive is about more than just dates and statutes. It is about the evolution of the male identity within the American constitutional framework. We are going to look at the landmark cases that challenged the status quo, the men who fought for parental equality when the law was stacked against them, and the socioeconomic forces that pushed the United States toward the no-fault revolution of the 1970s. By understanding the historical trends of the past, you gain a clearer perspective on the potential outcomes of the present. You begin to see that the frustrations of the modern system are not random. They are the result of centuries of legal tinkering, cultural shifts, and competing philosophies about what a family should be. This part of our journey sets the stage for the next 9 sections, where we will break down the specific mechanics of property division, the psychology of the courtroom, and the tactical reality of modern domestic relations. We are starting at the beginning because you cannot win a game if you do not understand how the rules were written, who wrote them, and why they were changed in the first place. This is the foundation of the masterclass, and we are just getting started. To understand the gravity of the current legal landscape for men, we must first analyze the 4 pillars of the traditional divorce era: condonation, connivance, collusion, and recrimination. These were the primary legal defenses used in the early to mid-20th century to prevent a divorce from occurring. Imagine you are a man in 1945 named Thomas. You have discovered that your spouse has been unfaithful, and you seek to dissolve the marriage. Under the doctrine of condonation, if your spouse can prove that you remained in the house and shared a bed with her for even one night after discovering the infidelity, the court would rule that you have legally forgiven the act. The potential outcome was that you were barred from ever using that specific act as grounds for divorce again. You were essentially trapped in the marriage by your own attempt at reconciliation. This created a legal environment where a single night of hesitation could result in a lifetime of mandatory domesticity. The doctrine of recrimination was perhaps the most devastating for men during this historical period. This rule stated that if both parties were at fault, neither was entitled to a divorce. If Thomas sued for divorce based on his wife's desertion, but she could prove that Thomas had a gambling habit or a brief period of unemployment that caused her stress, the judge would declare that both parties had unclean hands. The historical trend in these cases was for the judge to dismiss the petition entirely. In the eyes of the law, the state had a vested interest in keeping even the most miserable couples together to prevent them from becoming a burden on the public purse. This era, which lasted well into the 1960s, turned the American courtroom into a theater of organized perjury. Because the law required a villain and a saint, couples who both wanted to leave often had to coordinate elaborate lies to ensure the court would grant the decree. As we move into the 1950s, we see the solidification of the breadwinner model in matrimonial law. This was an era where the male identity was legally and financially tethered to the family unit with absolute rigidity. Case studies from this period show that even when a man was the innocent party, the potential outcomes often included permanent alimony. Alimony during this time was not viewed as a temporary bridge to self-sufficiency, but as a continuation of the husband's duty of support that lasted until the former wife remarried or died. For a man like David, working in a 1950s manufacturing plant, a divorce meant he would likely be working for 2 households for the rest of his natural life. The legal system viewed the man as an economic engine, and the divorce decree was essentially a lien against his future earnings. The radical shift occurred in 1969 with the passage of the Family Law Act in California, signed by Governor Ronald Reagan. This was the birth of the no-fault revolution. On the surface, it was intended to end the bitterness and lying of the fault-based system. However, the historical data shows that this transition had unintended consequences for men. Imagine if you are Mark, a professional living in the current year 2026. You find yourself in a divorce situation where your spouse has decided to walk away to pursue a different lifestyle. Under the old system, you might have had a defense or at least a leveraged position based on the lack of fault. In the no-fault era, the reason for the breakdown of the marriage is legally irrelevant. The court has shifted from a moral arbiter to an administrative liquidator. This means that a man can be a dedicated husband and a provider for 20 years, yet the court will treat the dissolution with the same clinical detachment as the closing of a business franchise. This shift brought about the rise of judicial discretion. In the old world, the rules were rigid but predictable. In the modern 2026 landscape, the potential outcomes are often at the whim of an individual judge's interpretation of what is equitable. This lack of predictability is one of the most significant stressors in the American legal history of divorce. When the law moved away from fault, it had to find a new way to divide property. This led to the emergence of the two dominant systems we see today: community property and equitable distribution. In community property states, the historical trend has been a strict 50-50 split of all assets acquired during the marriage, regardless of who earned the money. In equitable distribution states, the judge looks at a list of factors to decide what is fair. This is where the historical study of case law becomes vital. We see judges considering non-monetary contributions, such as homemaking or career support, as having a quantifiable cash value. For a man in 2026, this means his professional degree, the growth of his 401k, and even the future valuation of his business are all on the table. The legal history shows a steady expansion of what is considered marital property, moving from physical assets like a house or a car to intangible assets like professional goodwill. Consider the case study of Painter versus Bannister, which, although a custody case, illustrates the subjective nature of the best interests of the child standard that replaced the tender years doctrine. In this case, a father was denied custody because his lifestyle was deemed unconventional compared to the stable, middle-class life offered by the grandparents. This historical precedent is a warning for men in 2026. The court's version of stability often overrides biological rights. Even though the tender years doctrine, the idea that young children belong with their mothers, was officially abolished in the 1970s, the historical trends in custody awards suggest that the cultural residue of that doctrine still influences many modern rulings. The evolution of child support is another critical chapter. The 1984 Child Support Enforcement Amendments and the subsequent 1988 Family Support Act turned child support into a highly automated, formulaic system. This was a federal mandate to ensure that the state would not have to provide welfare for children. While the intent was fiscal responsibility, the result for many men was a system that failed to account for the actual costs of exercising parenting time. The potential outcomes became increasingly rigid, with state guidelines often taking a significant percentage of a man's gross income without considering his own cost of living or debt obligations. The legal history of divorce for men is a story of moving from a system of moral punishment to a system of social risk management. In the past, the law asked, "Who sinned?" Today, the law asks, "How do we ensure that neither party becomes a ward of the state?" This shift has fundamentally changed the strategy for any man navigating the process. It is no longer about proving you are a good person. It is about understanding the mathematical formulas and the historical precedents that govern asset division and support obligations. As we conclude this part of the masterclass, we have to look toward the most contested battlefield in the history of American divorce: the house and the retirement accounts. What happens when the law decides that your premarital savings have been commingled and are now communal property? In Part 3, we are going into the deep dive of property division mechanics. We will look at how the concept of transmutation can turn a man's separate property into marital property in a single afternoon. We will analyze the specific strategies used in 2026 to protect or target high-value assets. If you thought the history of fault was complex, wait until you see the legal gymnastics of modern equitable distribution. The battle for the future begins with the division of the past. The foundation of any property division in the American legal system begins with a concept that sounds simple, but is historically fraught with complexity: the distinction between separate property and marital property. To understand how a court in 2026 approaches your assets, you must first understand the historical evolution of the marital estate. In the early 20th century, the American legal system followed the title theory of property. This meant that if a man's name was on the deed to a house or the title of a vehicle, that property remained his upon dissolution. However, as we moved into the mid-century, specifically during the legal reforms of the 1970s and 80s, the concept of equitable distribution took hold in the majority of states. This shifted the focus from whose name is on the paper to the source of the funds and the timing of the acquisition. Imagine a man named Christopher in the year 2026. Christopher is entering a divorce after a 10-year marriage. Before he even met his spouse, he purchased a residential property in a growing suburb. In his mind, that house is his. It is a premarital asset. However, the American legal history of the last 50 years has developed two competing doctrines that will determine Christopher's potential outcomes: the inception of title rule and the source of funds rule. Under the inception of title rule, which is still used in several jurisdictions, the character of the property is fixed at the moment it is acquired. If Christopher bought it before the wedding, it remains separate property. But the historical trend in most modern courts has shifted toward the source of funds rule. This doctrine suggests that the property is not a static object, but a fluctuating investment. If Christopher used his salary earned during the marriage, which the law views as a marital asset, to pay down the mortgage, the marital estate now owns a percentage of that home's equity. This leads us to the most dangerous concept for men in the history of domestic relations law: transmutation. Transmutation is the legal process by which separate property is transformed into marital property. This usually happens in one of two ways: by agreement or by the commingling of assets. Let us look at a case study involving a man named Michael. In 2022, Michael inherited $250,000 from a relative. He kept this money in a separate brokerage account in his name only. By 2026, during his divorce proceedings, he assumes this money is protected. However, historical case studies show that if Michael ever transferred even $5,000 of that inheritance into a joint checking account to cover a month's mortgage or a family vacation, he may have commingled those funds beyond the point of recognition. Once the separate and marital funds are mixed, the law often applies a presumption that the entire account has been transmuted into marital property. The burden of proof then shifts to Michael to trace every single dollar back to its separate source, a process that requires forensic accounting and can cost tens of thousands of dollars in legal fees. The legal history of the marital home provides another layer of complexity. Historically, the home was viewed as the ultimate sanctuary, often awarded to the primary caregiver to ensure stability for the children. In 2026, this trend continues, but with a significant financial twist. Even if a man can prove that the home is partially his separate property, the court may apply the exclusive possession doctrine. This allows the spouse to remain in the home for a period of years, sometimes until the youngest child reaches 18, while the man remains responsible for a portion of the mortgage, taxes, and insurance. This creates a scenario where a man is legally barred from his primary asset, while still being financially obligated to maintain it. Now, we must examine the evolution of active versus passive appreciation. This is a critical area for business owners and investors. Suppose a man named Robert owns a tech startup. He founded the company 3 years before his marriage. At the time of the wedding, the company was valued at $1 million. By 2026, the company is valued at $10 million. Robert argues that because the business was premarital, the entire $10 million is his. However, the American legal system distinguishes between passive growth, such as market fluctuations or inflation, and active growth, which is the result of the owner's labor and talent during the marriage. Historical trends in case law suggest that because Robert worked on the business while married, a significant portion of that $9 million increase in value will be classified as marital property. The courts view his marital labor as an asset that belongs to the partnership. This means his spouse could be entitled to a cash buyout of half the active appreciation, potentially forcing Robert to sell shares or take on massive debt to satisfy the judgment. We also have to address the Retirement Equity Act of 1984, a landmark piece of federal legislation that fundamentally changed the landscape for men's pensions and 401k accounts. Before this act, retirement accounts were often viewed as the individual property of the worker. Today, the Qualified Domestic Relations Order, or QDRO, is a standard tool used to carve out a portion of a man's future retirement and hand it over to his former spouse. The historical data indicates that for many men, their retirement account is their largest single asset, often exceeding the equity in their home. The law treats these accounts as deferred compensation for work performed during the marriage. Imagine if Robert has been diligently contributing to a 401k for 20 years. If he was married for 15 of those years, the court will use a coverture fraction to determine exactly how much of that account is marital. In 2026, this is almost automated, but it remains one of the most significant wealth transfers in the American legal process. Another fascinating historical shift is the treatment of professional degrees and licenses. In the 1970s and 80s, some states, most notably New York in the famous case of O'Brien v. O'Brien, ruled that a medical license or a law degree obtained during marriage was a marital asset with a quantifiable value. The court reasoned that since the spouse supported the student during the lean years, they were entitled to a share of the enhanced earning capacity that the degree provided. While many states have moved away from this extreme position, the historical trend has left behind a system where reimbursement alimony, or restorative equity, is often used to compensate a spouse for their contribution to a man's career growth. This brings us to the mechanics of the equalization payment. In most 2026 divorce cases, the court does not want to literally split every chair and spoon in half. Instead, they create a balance sheet. On one side are the assets, on the other are the debts. If a man ends up with more of the assets, perhaps he keeps his business and his retirement, he must pay his spouse an equalization payment to level the scales. This is where the historical study of valuation becomes vital. How do you value a private business? How do you value a pension that won't pay out for 20 years? The legal history is filled with battles over discount rates and capitalization of earnings. The property division stage is where the emotional reality of divorce meets the cold, mathematical history of the law. It is a process that rewards documentation and punishes assumptions. Many men enter the courtroom thinking the law is about what is fair in a moral sense, but the historical evolution of American property law shows it is actually about the liquidation of a partnership. But property is only half of the equation. Once the assets are divided, the court turns its attention to the ongoing flow of income. This is the realm of spousal support, more commonly known as alimony. In Part 4, we are going to dive into the shocking evolution of alimony from its origins as a lifelong entitlement to its modern form as rehabilitative support. We will look at how the Tax Cuts and Jobs Act of 2017 fundamentally changed the math of alimony for men, and why the permanent alimony laws are being dismantled in states like Florida and beyond. If you think property division is complex, wait until you see the historical shift in how the state determines how much of your future paycheck belongs to your past. The history of spousal support, commonly known as alimony, is perhaps the most emotionally charged chapter in the American legal record. To understand the potential outcomes for a man like James in the year 2026, we have to look back at the ecclesiastical courts of England, where alimony was not a post-divorce payment, but a tool used during legal separation to ensure a husband continued his duty of support. Because a full divorce was nearly impossible to obtain, the marriage remained legally intact, and so did the financial obligation. When the United States adopted these principles, they were codified into a system that viewed alimony as a lifelong entitlement for a woman who had fulfilled her domestic role. However, the historical trend over the last 40 years has seen a radical transformation from permanent support to what is now known as rehabilitative or durational alimony. Imagine James, a 52-year-old software architect in 2026, ending a 24-year marriage. In the 1970s, James would likely have been ordered to pay permanent alimony until his former spouse either remarried or passed away. But the modern legal landscape is governed by a different set of philosophies. Today, the court views alimony through the lens of the marital standard of living. This is a technical calculation where the judge looks at the lifestyle established during the marriage, the vacations, the cars, the zip code, and the discretionary spending, and attempts to ensure that both parties can maintain a version of that lifestyle. For James, this means the court isn't just looking at what his spouse needs to survive. They are looking at what is required to keep her in the manner to which she has become accustomed. The first major shift we must analyze is the transition toward rehabilitative alimony. This concept emerged in the 1980s as more women entered the workforce. The legal theory shifted from permanent support to providing a bridge for the lower-earning spouse to become self-sufficient. If James's spouse has a degree but hasn't worked in 15 years, a 2026 court might award rehabilitative alimony for a period of 3 to 5 years. This is specifically intended to cover the costs of retraining, education, or re-entry into the professional world. Historical data from various state courts shows that judges are increasingly hesitant to award permanent support unless the marriage was of long duration, typically 20 years or more, or if there are significant health issues involved. However, a massive legal pivot occurred on January 1, 2019, which fundamentally changed math for every man in America. Before this date, under the old tax code, alimony was tax-deductible for the payer and taxable income for the recipient. This created a tax subsidy that allowed men to pay a higher gross amount because the net cost was lower after their tax deduction. The Tax Cuts and Jobs Act of 2017 repealed this deduction for all divorce decrees signed after the end of 2018. In 2026, this remains the standard. For James, this means if he is ordered to pay $4,000 a month in alimony, he is paying that with after-tax dollars. He has already paid his 30% or 35% income tax on that money, and his former spouse receives it tax-free. This has led to a historical trend of lower nominal alimony awards. But the actual economic burden on the pair has increased because the tax break is gone. We also need to look at the rise of durational alimony guidelines. States like Massachusetts and Florida have been at the forefront of this legal evolution. In Massachusetts, the Alimony Reform Act established a formula based on the length of the marriage. If a marriage lasted 10 years, the alimony might only last for 5 to 7 years. In 2026, many jurisdictions have adopted similar sunset clauses. The era of "until death do us part" alimony is largely being replaced by a system that links the duration of the payment to the duration of the union. This provides a level of predictability that was missing in the 1950s and 60s, where a judge's personal whim could dictate a man's financial future for decades. Another critical historical development is the cohabitation clause. Historically, alimony only ended upon the remarriage of the recipient. This led to the private investigator era of the 1990s, where men would hire professionals to prove their former spouse was living with a new partner to stop the payments. In 2026, the legal standard in many states has evolved to include supportive relationships. If James can demonstrate that his former spouse is living with someone and they are sharing expenses, even if they aren't married, the court has the authority to reduce or terminate the alimony. Case studies show that modern courts are more willing to look at the economic reality of a household rather than just a marriage license. We must also address the concept of double dipping. This is a sophisticated area of legal history where the division of assets and the calculation of alimony collide. Imagine James owns a consulting firm. In the property division phase, the business is valued at $2 million based on its future earnings, and James's spouse is awarded $1 million as her share. In the alimony phase, the court then looks at the income James draws from that same business to calculate his monthly support payment. James's legal team would argue that this is double dipping. The spouse is getting a piece of the asset value, and then a piece of the income that the asset generates. Historical trends in state supreme courts, such as in the landmark cases of Stenkin versus Stenkin or Heller versus Heller, have attempted to draw a line to prevent this, but it remains one of the most contested technicalities in 2026 litigation. Then there is the issue of imputed income. What happens if a man decides to take a lower-paying job or retire early to avoid high alimony payments? The American legal system has developed a robust set of precedents to handle voluntary underemployment. If James, who earns $300,000 a year, suddenly decides to become a high school coach earning $50,000 during the divorce, the court will likely impute his former income to him. They will look at his work history, his qualifications, and the prevailing wages in his field and calculate his alimony obligation as if he were still making $300,000. This historical doctrine ensures that a party cannot unilaterally change the financial rules of the game to the detriment of the other. As we look at the potential outcomes in 2026, we see a system that is moving toward a more formulaic, math-based approach. The days of the alimony for life standard are fading, replaced by a rehabilitative philosophy that encourages independence. However, the loss of the tax deduction and the aggressive pursuit of the marital standard of living mean that for high-earning men, the stakes have never been higher. The math of the past is not the math of the present, and understanding these historical shifts is the only way to navigate the negotiation table. But alimony is only the financial side of the aftermath. There is another, arguably more important battleground: the children. For over a century, the law operated under a heavy bias that the father was the provider and the mother was the nurturer. In Part 5, we are going to dive into the revolutionary shift toward 50-50 shared parenting. We will look at how parenting plans became the law of the land, the data behind the move away from visitation, and the rise of the friendly parent doctrine. If you think the financial stakes are high, wait until you see the historical evolution of how the state decides who gets to raise the next generation. The fight for time is the ultimate deep dive. The shift in the American legal system regarding the custody of children is a journey from viewing children as property to viewing them as individuals with their own rights. To understand the potential outcomes for a father like Brian in the year 2026, we have to examine the radical pendulum swings of the last 2 centuries. In the early 19th century, the legal trend was actually a paternal preference. Under English common law, children were seen as an economic asset, and the father, as the sole provider and legal head of the household, had an absolute right to custody. If a marriage dissolved in 1830, the children almost always stayed with the father because he held the keys to their survival and social standing. However, as the 19th century progressed, the legal system underwent a massive shift toward the tender years doctrine. This doctrine created a legal presumption that during their youngest years, children required the unique nurturing only a mother could provide. This historical trend effectively locked men out of primary caretaking roles for over a century, establishing a baseline where the father was relegated to the role of a periodic visitor. By the 1970s, the American legal landscape began to move away from the tender years doctrine toward a gender-neutral standard known as the best interests of the child. This sounds equitable on paper, but in practice, it introduced a high level of judicial discretion that often relied on the primary caretaker rule. This rule focused on who did the day-to-day tasks, who made the school lunches, who took the child to the doctor, and who stayed home when they were sick. Historically, because of traditional gender roles in the 20th century, this rule continued to favor mothers in the majority of case studies. For a man in the 1980s or 90s, the potential outcome was frequently the standard visitation schedule, which usually meant every other weekend, 1 weeknight for dinner, and alternating holidays. This created the Disney dad phenomenon, where fathers felt they had to squeeze an entire parenting relationship into 48 hours of high-intensity entertainment every 2 weeks. As we move into the landscape of 2026, we are witnessing the most significant change in child custody history: the rise of the rebuttable presumption of shared parenting. This is a movement where state legislatures, starting with Kentucky in 2018 and followed by several other states like Florida and Arizona, have changed their statutes to mandate that 50-50 equal time is the starting point for any custody discussion. The law no longer assumes one parent is primary and the other is secondary. Instead, it assumes that both parents are equally vital to the child's development. For Brian in 2026, this means that unless there is clear and convincing evidence of harm, such as substance abuse or domestic violence, the court begins with the premise that his children deserve half of their time with him. To navigate this 2026 reality, we must look at the mechanics of the modern parenting plan. In historical trends, custody was a winner-take-all scenario. Today, the legal system breaks custody down into 2 distinct categories: legal custody and physical custody. Legal custody refers to decision-making authority over major life events, where the child goes to school, what religious training they receive, and what medical treatments they undergo. In the vast majority of modern case studies, joint legal custody is the default. This requires parents to consult and agree on these big-picture items. Physical custody refers to where the child actually sleeps. The historical trend toward 50-50 physical custody has led to the creation of specific schedules that define the modern male experience in divorce. Imagine Brian is setting up his 2026 parenting plan. He might look at a 2-2-3 schedule, where the children spend 2 days with one parent, 2 days with the other, and 3 days the weekend with the first parent, then rotate. Or he might look at the 5-2-2-5 schedule, which provides more consistency by ensuring the children are always with Brian on Mondays and Tuesdays, and with the other parent on Wednesdays and Thursdays, while the weekends alternate. These schedules are the byproduct of decades of psychological data, showing that children who have significant, consistent time with their fathers show higher levels of academic success, better emotional regulation, and lower rates of substance abuse later in life. The legal history has finally caught up with the social science. However, a critical factor in the 2026 legal system is the friendly parent doctrine. This is a historical shift in how judges evaluate which parent is more fit. Under this doctrine, the court looks at which parent is more likely to encourage a positive relationship with the other parent. If Brian is seen as cooperative, flexible with the schedule, and supportive of the children's bond with their mother, the court views him more favorably. Conversely, if one parent attempts to engage in parental alienation, a term that gained legal traction in the 1980s and is now heavily scrutinized in 2026, they risk losing custody entirely. The historical trend has moved from rewarding the parent who can prove the other is bad to rewarding the parent who can prove they are the most cooperative. We must also analyze the evolution of child support in the context of shared parenting. Historically, child support was a straight transfer of wealth from the non-custodial parent to the custodial parent. But in the 2026 landscape, most states use the income shares model. This model looks at the combined income of both parents and then applies a percentage based on the number of children. If Brian has 50-50 custody, many jurisdictions now apply a cross-custody multiplier. This acknowledges that Brian is maintaining a full household for the children, with their own bedrooms, clothes, and food, half of the time. This shift has significantly altered the potential outcomes of child support awards, often reducing the transfer payment between households when parenting time is equal. A newer trend in 2026 is the concept of nesting. This is a temporary arrangement where the children stay in the family home, and the parents rotate in and out. While it was once considered a niche practice, case studies show it is increasingly used during the transitional phase of a divorce to minimize the trauma for the children. This is the ultimate evolution of the best interests of the child standard, prioritizing the stability of the children's environment over the convenience of the parents. However, the path to 50-50 is not always a smooth historical progression. We have to look at the rise of the high-conflict divorce. As the legal system has removed the ability to fight over fault or property as easily as in the past, the children have often become the last remaining battlefield. In 2026, the use of guardian ad litems and custody evaluators has reached an all-time high. These are third-party professionals appointed by the court to investigate the family dynamic. A man like Brian must understand that his every interaction, his social media presence, and his home environment are subject to intense scrutiny during this process. The legal history of custody is a shift from the power of the father to the power of the expert witness. Understanding the history of custody for men is about recognizing that the system is no longer built on a single assumption of who the primary parent should be. It is built on a complex set of statutory factors that reward consistency, cooperation, and documented involvement. The fight for time is no longer just about showing up in court. It is about the historical work of being an active, engaged parent from day one. But as the legal system has become more focused on equality in parenting, it has also become more vulnerable to tactical maneuvers. What happens when the push for 50-50 is met with a strategy designed to stop the process in its tracks? In Part 6, we are going to dive into the most controversial and high-stakes area of American legal history: the weaponization of the system through the silver bullet of false allegations. We will look at how the 1994 Violence Against Women Act and subsequent state laws changed the burden of proof in domestic relations cases, and what the 2026 data says about the use of temporary restraining orders as a tactical advantage in custody battles. This is the dark side of legal history that every man needs to understand before he enters the arena. The transition from a system focused on moral fault to one focused on administrative equity was intended to reduce conflict, but the historical record reveals a countertrend that legal scholars often refer to as the silver bullet strategy. To understand the potential outcomes for a man named Anthony in the year 2026, we must examine the intersection of family law and domestic violence legislation, specifically the 1994 Violence Against Women Act and its subsequent reauthorizations. While these laws were designed to provide essential protections for true victims, the historical data illustrates how the procedural mechanics of these statutes can be utilized as a tactical lever in high-stakes custody and property disputes. In the American legal history of the last 30 years, the issuance of a temporary restraining order, or TRO, has become one of the most powerful and disruptive tools in the family court arsenal. Imagine Anthony, a mid-level executive with no criminal record and a clean history of parental involvement. In 2026, Anthony finds himself in a contested divorce where the 50-50 custody presumption is the legal starting point. However, on a Friday afternoon, he is served with an ex parte domestic violence restraining order. The term ex parte is a critical piece of legal history. It means the order was granted by a judge based solely on the testimony of one party, without Anthony being present or even notified of the hearing. Historically, the legal standard for these initial orders has been lowered to a preponderance of the evidence, which essentially means the judge only needs to believe the allegation is more likely than not to be true, often based only on a signed affidavit. The step-by-step reality of this historical trend is immediate and devastating. Step 1 is the physical removal. Within minutes of being served, Anthony is legally barred from his own home, often escorted by law enforcement with only a few personal items. Step 2 is the total severance of parental contact. Most temporary orders include a stay-away provision that covers not just the spouse, but the children as well. Step 3 is the creation of a legal vacuum. Anthony may have to wait 14 to 21 days for a return hearing where he can finally present his side of the story. Historical case studies show that in these 2 to 3 weeks, the entire trajectory of the divorce can shift. This brings us to the status quo trap. In the historical evolution of child custody, judges have always prioritized stability. If Anthony is removed from the home for 3 weeks, or if the litigation drags out the return hearing for months, the children begin to form a new routine in his absence. By the time Anthony gets his day in court to disprove a false or exaggerated allegation, the other party's legal team can argue that returning to a 50-50 schedule would be disruptive to the children's new established status quo. The historical trend shows that once a man loses physical presence in the home via a TRO, the potential outcomes for regaining equal parenting time become significantly more complex and expensive. We must also analyze the 2026 data regarding the expansion of the definition of abuse. Historically, domestic violence was defined by physical harm or the threat of physical harm. However, a major legal shift occurred in the early 2020s as many states began adopting the concept of coercive control. This expanded definition includes non-physical behaviors such as financial control, monitoring of communications, or emotional manipulation. While this expansion was intended to capture the nuances of domestic abuse, the historical data suggests it has also increased the frequency of TRO filings. For Anthony, an argument over a credit card statement or a firm request for a specific parenting schedule could now, under certain judicial interpretations, be categorized as coercive control. This reflects a historical trend where the threshold for state intervention in the family unit has moved from a high bar of criminal conduct to a lower bar of behavioral assessment. The impact of this historical shift extends beyond custody into the realm of property and finance. When a TRO is issued, the man often remains financially responsible for the mortgage and utilities of the home. He is no longer allowed to enter. This is the financial double whammy of the silver bullet. Historical trends in 2026 indicate that men in this position face a war of attrition. They are paying for a separate residence, paying for their own legal defense, and potentially paying the household expenses of their accuser. The historical data from legal aid organizations and bar associations suggests that the financial strain of fighting a TRO leads many men to settle for unfavorable property divisions or less parenting time just to end the litigation and stop the financial bleeding. Furthermore, we must look at the historical data concerning the dismissal rate of these orders. In many metropolitan jurisdictions, case studies show that up to 70% of temporary restraining orders are either dismissed by the court at the final hearing or dropped by the petitioner once a favorable settlement is reached. However, the legal system provides very few mechanisms for a man like Anthony to recover the costs associated with a false allegation. Historically, the law has prioritized the safety of potential victims over the due process rights of the accused in the initial stages of a domestic case. While this is a foundational principle of modern American jurisprudence, the unintended consequence has been the creation of a tactical shortcut that bypasses the 50-50 custody presumptions we discussed in previous chapters. Another historical development is the nexus between restraining orders and professional standing. In the 2026 landscape, an active TRO often appears on background checks, can trigger a review of professional licenses, and may lead to the loss of a security clearance. This means the silver bullet doesn't just target a man's role in the family. It can target his ability to earn the income that supports that family. We see this in case studies involving pilots, medical professionals, and government contractors, where a single unproven allegation can suspend a career indefinitely. The historical trend has moved toward a zero-tolerance policy in the workplace, which increases the leverage of a TRO in a divorce negotiation. To understand the 2026 environment, one must also look at the rise of the rebuttal of the friendly parent presumption. As we mentioned in Part 5, courts prefer the friendly parent. However, if a parent successfully obtains a restraining order, they are legally exempt from the requirement to be friendly or cooperative. The historical data shows that the silver bullet effectively neutralizes the friendly parent doctrine, allowing one party to be completely uncooperative under the protection of a court order. As we conclude this analysis of the legal weaponization of allegations, it is important to note that the system is beginning to see a push for legislative reform. Some states are exploring mandatory sanctions for proven perjury in family court, but the historical trend remains one of extreme caution on the part of judges. For a man navigating this history, the lesson is clear. The law is not a neutral observer. It is a powerful machine that can be activated by a single affidavit. The battle in 2026 is often won or lost not on the facts of the marriage, but on the management of the first 48 hours of the legal separation. But the silver bullet is only one side of the tactical landscape. Even if a man survives the allegations and maintains his presence in the home, he still faces the most grueling part of the American legal process: the discovery phase and the financial war of attrition. In Part 7, we are going into the deep dive of forensic accounting and the discovery process. We will look at how the legal history of transparency has turned into a tool for exhaustive and expensive investigations. We will analyze the data on how legal fees are used as a weapon to force a surrender, and what the 2026 trends say about the cost of proving the truth. The paper trail is where the next phase of the masterclass begins. The American legal history of discovery is a transition from a system of trial by ambush to one of radical transparency. Prior to the mid-20th century, a man could walk into a divorce hearing with his financial records tucked away, only revealing what was absolutely necessary to satisfy the judge. However, the adoption of the Federal Rules of Civil Procedure in 1938, which many states subsequently mirrored in their family codes, changed the game forever. In the 2026 legal landscape, discovery is no longer a simple exchange of documents. It is a high-tech, data-driven financial war of attrition. To understand the potential outcomes for a man like Gregory, a mid-sized business owner in 2026, we have to examine how the paper trail has evolved into a digital net that catches every single cent, text message, and location ping from the last decade of a marriage. Imagine Gregory. He has spent 15 years building a successful landscaping and hardscaping firm. He is entering a divorce, and his spouse's legal team has just served him with a 90-page document consisting of interrogatories, requests for production, and requests for admission. In the 1960s, Gregory might have been asked for his tax returns and a bank statement. In 2026, the historical trend in discovery has moved toward the electronic discovery reference model. Gregory is now required to produce not just his paper records, but his QuickBooks files, his Venmo history, his cryptocurrency wallet addresses, and his Amazon purchase history for the last 5 years. The legal theory behind this is that the marital estate is entitled to full disclosure, but the practical reality for Gregory is a monumental administrative burden that costs thousands of dollars in billable hours just to organize. The first major component of this modern financial war is the interrogatory. These are written questions that must be answered under oath. Historically, these were used to identify assets. In 2026, they are used to trap men in inconsistencies. For example, Gregory might be asked to list every person he has spent more than $50 on in the last 2 years. If Gregory misses a single business lunch or a gift for a family member, the opposing counsel can use that omission to argue that he is hiding assets or engaging in wasteful dissipation of marital funds. Wasteful dissipation is a critical historical concept. It refers to the use of marital money for non-marital purposes, such as gambling, expensive hobbies, or relationships outside the marriage. If the court finds that Gregory dissipated funds, he may be ordered to pay that money back to the marital estate out of his share of the property division. The second component is the request for production. This is where the paper trail becomes a mountain. Historical case studies show that in high-stakes divorces, the volume of data can reach several terabytes. Gregory's spouse's lawyer will demand every email sent from his business account that mentions the word cash, every receipt for fuel, and every credit card statement. The goal here is often twofold: to find hidden value and to increase the cost of litigation. This is what we call the financial war of attrition. If Gregory has to pay his own lawyer to review 10,000 emails and then pay his spouse's lawyer's fees, a common historical trend known as an interim fee award, he may find himself financially exhausted before he ever reaches a courtroom. In 2026, the role of the forensic accountant has become central to the male experience in divorce. Forensic accounting is the application of accounting principles to legal problems. These professionals perform what is known as a lifestyle analysis. They don't just look at what Gregory claims he earns, they look at how he lives. If Gregory reports a net income of $100,000 but his mortgage, car payments, and country club dues total $150,000, the forensic accountant will find the phantom income. Historically, this has been used to uncover under-the-table payments in cash-heavy businesses. The potential outcome for Gregory is that the court may attribute a much higher income to him for the purposes of alimony and child support, regardless of what his tax returns say. This historical shift from reported income to available cash flow is one of the most significant developments in modern family law. We must also analyze the evolution of digital discovery. In the current year 2026, a man's smartphone is the primary witness against him. Historical trends show that courts now routinely grant subpoenas for social media archives, cloud storage, and even GPS data from vehicle telematics. If Gregory claimed he was working late but his truck's GPS shows he was at a casino 3 towns over, his credibility is destroyed. Credibility is the invisible currency of the family court. Once a judge believes a man has been dishonest about a small detail in discovery, they are much more likely to believe he is being dishonest about large assets like business valuations or offshore accounts. Another critical historical development is the concept of the mandatory disclosure rule. In many states, you no longer wait for the other side to ask for documents. You are legally required to provide a comprehensive financial affidavit and supporting documents within 30 to 60 days of filing. Failure to do so can result in sanctions, including the striking of your pleadings, or the court assuming that everything the other side says about your finances is true. This shift was designed to speed up the process, but in 2026, it often serves as a high-pressure tactic to catch men who are unprepared for the sheer volume of documentation required. Now, consider the case study of the hidden asset trap. Historically, some men attempted to park money with friends or family members during a divorce. They might pay back a loan to a brother that never actually existed, with the understanding that the money would be returned after the divorce was final. In 2026, the paper trail makes this almost impossible to hide. Forensic accountants use Benford's law and other mathematical models to spot anomalies in spending patterns. If Gregory suddenly starts making large cash withdrawals or paying off obscure debts, the system will flag it. The historical data suggests that the penalties for hiding assets are far more severe than the cost of simply dividing them. In some jurisdictions, a judge can award 100% of a hidden asset to the other spouse as a punitive measure. The financial war of attrition also involves the use of depositions. A deposition is an out-of-court testimony where Gregory must sit in a room for 6 to 8 hours while the opposing lawyer asks him questions about every aspect of his life. Historically, depositions were about fact-finding. Today, they are about psychological endurance. Every hour of a deposition costs hundreds of dollars in reporter fees, videographer fees, and attorney time. For a man in 2026, the deposition is often the moment where the reality of the legal process hits home, where his entire life history is scrutinized under a microscope. As we look at the potential outcomes of the discovery phase, it becomes clear that the American legal history of divorce has moved toward a state of total information awareness. You cannot hide from the data. The goal for a man in 2026 is not to suppress the truth, but to manage the presentation of the facts so that his business and his future are not dismantled by a narrative of greed or dishonesty. The paper trail is a map of the marriage, and the lawyers are the cartographers who decide which landmarks to highlight. But even after all the documents are exchanged and the accountants have finished their audits, the most difficult part of the process is often the human element. How does the system handle the emotions, the anger, and the psychological impact of this total exposure? In Part 8, we are going to dive into the history of mediation and psychological warfare. We will look at why 95% of cases settle before trial, the rise of the custody evaluator as a psychological judge, and how the parental alienation debate is shaping the 2026 courtroom. If discovery is the war of the wallet, the next phase is the war of the mind. The strategy moves from the spreadsheet to the settlement table. The transition from the discovery phase to the settlement table represents the most significant psychological hurdle in the American legal history of divorce. While the 19th century system relied on a public trial to shame the guilty party, the modern era, and specifically the landscape of 2026, relies on a high-pressure environment known as alternative dispute resolution or ADR. Statistics from the American Bar Association and various state court systems consistently show that approximately 95% of divorce cases settle before they ever reach a final trial. This is not necessarily because the parties find a sudden wellspring of mutual respect. Rather, it is a historical trend driven by the astronomical costs of litigation and the strategic use of psychological pressure. To understand the potential outcomes for a man named Kevin in 2026, we must analyze the evolution of the mediation mandate and the rise of the psychological expert as a shadow judge. Imagine Kevin, a mid-career professional who has spent the last 18 months and $50,000 on the discovery process we analyzed in the previous chapter. He is now ordered by the court to attend mandatory mediation. Historically, mediation gained traction in the late 1970s and early 1980s as a way to clear backlogged court dockets. What began as a voluntary option has, in 2026, become a jurisdictional requirement. If Kevin refuses to participate in good faith, the court can sanction him or view his behavior as obstructive, potentially impacting his custody standing. The mediation room is the first major site of psychological warfare. Kevin sits in one room with his attorney, while his spouse sits in another. The mediator, acting in a role defined by the historical practice of shuttle diplomacy, moves between the rooms, highlighting the weaknesses in each party's case. The psychological tactic often employed here is the fear of the unknown. The mediator will remind Kevin that if he does not settle today, he is handing his entire future, his assets, his income, and his relationship with his children, over to a judge who may only spend 4 hours listening to a case that has lasted 20 years. This historical move toward mediation has shifted the power from the law itself to the skill of the negotiator. Case studies show that men often settle for less than their legal entitlement during these sessions, simply to stop the emotional hemorrhaging. This is the sunken cost fallacy in action. Kevin has already lost so much time and money that he is willing to accept a suboptimal outcome just to secure a sense of finality. However, the war of the mind extends far beyond the mediation table into the realm of the custody evaluation, often referred to as a 730 evaluation in states like California. Historically, the use of psychological experts in custody cases began in the mid-20th century, but exploded in the 1990s. In 2026, these evaluators are the most powerful individuals in the family court system. They are typically forensic psychologists who conduct deep dives into the mental health and parenting capabilities of both parties. Imagine if Kevin is subjected to this. The evaluator will visit his home, observe him interacting with his children, and administer a battery of tests, such as the MMPI-2, Minnesota Multiphasic Personality Inventory. The historical data on these evaluations suggests that they are highly subjective. Despite the use of standardized testing, the final report often hinges on the evaluator's personal interpretation of what constitutes a stable home. For a man in 2026, the potential outcome of a negative custody evaluation is catastrophic. Because judges are not psychologists, they almost always adopt the evaluator's recommendations in their final orders. This has created a system where the battle is won or lost during the home visit and the clinical interview. Kevin must understand that every word he speaks to the evaluator is being analyzed for signs of aggression, instability, or what is now a major legal battleground, parental alienation. The history of parental alienation (PA) is one of the most controversial chapters in American legal studies. First popularized by Richard Gardner in the 1980s, the concept describes a situation where one parent systematically brainwashes a child to reject the other parent. In the early 2000s, PA was often dismissed as a junk science defense used by fathers. However, by 2026, the legal trend has shifted. Many jurisdictions now recognize the behaviors associated with alienation, such as disparaging the other parent, limiting communication, or making the child a confidant in the divorce, as form of emotional abuse. Kevin's case study might involve a scenario where his children suddenly refuse to see him after a year of consistent 50-50 parenting. In 2026, the court's response to this is significantly more sophisticated than in the past. We see the rise of reunification therapy and reunification camps, which are intensive programs designed to repair the bond between the alienated parent and the child. The historical record shows that these interventions are controversial and expensive, often costing tens of thousands of dollars not covered by insurance. For Kevin, proving alienation requires a meticulous paper trail of text messages, emails, and witness testimony to show a pattern of interference. The war of the mind is fought in the subtle margins of a child's loyalty. We must also analyze the tactic of the nuisance value settlement. This is a historical trend where one party uses the psychological and financial exhaustion of the other as a closing move. If Kevin's spouse knows that Kevin is desperate to maintain his professional standing and avoid the public exposure of a trial, they may demand an extra 10% of the retirement account or a higher alimony duration at the 11th hour. They are betting that Kevin's psychological floor has been reached. Data from 2026 indicates that a significant number of settlements are reached in the courthouse hallway, minutes before a trial is scheduled to begin, under the extreme pressure of the looming judicial gavel. Furthermore, the 2026 legal landscape has introduced the concept of the friendly parent presumption as a psychological test. In the settlement phase, the party who appears most willing to facilitate the other's relationship with the children often gains the upper hand. If Kevin can demonstrate that he has consistently offered extra time, shared information, and remained calm under provocation, he builds a psychological narrative of the superior parent. Historically, men who reacted to the stress of divorce with anger or withdrawal were penalized by the court. The modern strategy for men is the adoption of a business-like persona, treating the divorce as a corporate dissolution rather than a personal tragedy. As we look at the potential outcomes of this phase, it is clear that the American legal history of divorce has moved from the courtroom to the conference room. The strategy is no longer just about the law, it is about managing the psychological narrative that will be presented to the mediator or the evaluator. Kevin is not just fighting for his house or his kids, he is fighting for the court's perception of his character. This is the most taxing part of the process, as it requires a man to remain emotionally disciplined while his entire life is being deconstructed. But what happens when mediation fails? What happens when the psychological warfare doesn't lead to a settlement, and you become part of the 5% of cases that actually go to trial? In Part 9, we are going to dive into the anatomy of a divorce trial. We will look at the history of the bench trial, the rules of evidence that keep the truth hidden, and the high-stakes world of the appellate court. We will analyze the data on how often trial results are actually overturned and why the final judgment is rarely the end of the story. The gloves come off when the settlement table is abandoned for the witness stand. When a man enters a courtroom in 2026 for a final divorce trial, he is stepping into a legal environment that has been refined over centuries to prioritize administrative efficiency and judicial discretion over the dramatic jury trials we see in film and television. To understand the potential outcomes for a man like Stephen, a 45-year-old software engineer, we have to look at the historical transition from the law courts of the early American Republic to the modern courts of equity. Historically, many civil matters could be heard by a jury of one's peers. However, the American legal trend over the last century has solidified the bench trial as the standard for domestic relations. This means that Stephen's fate, his assets, his future income, and his access to his children is decided by a single individual, the judge. The bench trial is a black box of judicial discretion. Imagine Stephen sitting at the petitioner's table. His entire life has been distilled into a stack of exhibits. The trial process follows a rigid step-by-step historical structure. It begins with the opening statements, where each attorney provides a roadmap of the evidence they intend to present. For Stephen, this is the first time the judge hears his narrative in a cohesive way. But the real battle occurs during the case-in-chief, where the rules of evidence act as a filter for what the judge is actually allowed to consider. One of the most significant hurdles for men in the history of American trial law is the hearsay rule. Historically, hearsay was excluded to ensure that only reliable, first-hand testimony reached the trier of fact. In a 2026 divorce trial, this means that if Stephen wants to testify about something his spouse's sister told him regarding hidden assets, it will likely be sustained as hearsay and stricken from the record. Stephen may feel that the truth is being suppressed, but the historical trend of the rules of evidence is designed to prevent the trial from devolving into a series of unverified rumors. This requires a man to have a meticulous paper trail, emails, bank statements, and text messages that can be authenticated and admitted as evidence under specific exceptions, such as the business records exception or the admission of a party opponent. The heart of the trial is the testimony. When Stephen takes the witness stand, he undergoes direct examination by his own lawyer and cross-examination by the opposing counsel. The historical trend in cross-examination for family law is often referred to as the impeachment of credibility. The goal of the opposing attorney is not necessarily to prove Stephen is a bad person, but to show that he is an unreliable witness. If Stephen's testimony contradicts a single line in a deposition he gave 6 months earlier, or a single figure in a financial affidavit from a year ago, the opposing counsel will use that inconsistency to undermine his entire case. The potential outcome of a successful impeachment is that the judge may discount Stephen's testimony entirely, even on matters where he is telling the absolute truth. Expert witnesses play a pivotal role in this historical stage. We have already discussed forensic accountants and custody evaluators, but during the trial, These professionals must defend their findings under oath. Stephen might watch as his own expert is grilled on their methodology. Historical case studies show that trials often turn into a battle of the experts. If the judge finds the spouse's business valuator more credible than Stephen's, the valuation of Stephen's company could swing by hundreds of thousands of dollars. This illustrates the high-stakes nature of the trial phase. It is a contest of presentation as much as it is a contest of facts. We must also analyze the concept of the statement of decision. Historically, after a trial ends, the judge does not just issue a simple win or loss. In many jurisdictions in 2026, a party can request a written explanation of the factual and legal basis for the judge's ruling. For Stephen, this document is vital. It forces the judge to show their work. If the judge awards Stephen's spouse 60% of the assets, the statement of decision must explain why that is equitable based on the evidence presented. This historical requirement is the primary safeguard against arbitrary judicial power, and it provides the necessary foundation for the next stage of the legal journey, the appeal. However, the historical data on the appellate process provides a sobering reality for men. An appeal is not a second trial. The appellate court does not hear new evidence, and they do not listen to witnesses. They only review the transcript of the trial to see if the judge made a reversible error of law. For Stephen, the potential outcomes of an appeal are statistically low. Historically, appellate courts give great deference to the trial judge's findings of fact. This is known as the abuse of discretion standard. Unless Stephen can prove that the judge fundamentally misapplied the law, or that there was absolutely no evidence to support the ruling, the trial court's decision will stand. This historical trend emphasizes why the trial itself is the final opportunity to shape the narrative. The final judgment, once signed by the judge and entered into the record, becomes the law of Stephen's life. It dictates his monthly budget, his holiday schedule, and his long-term financial security. But the American legal history of divorce teaches us that a final judgment is rarely truly final. In the 20th century, the legal system developed the doctrine of the material change in circumstances. This means that while the property division is usually permanent, the orders regarding child support, alimony, and custody remain under the court's ongoing jurisdiction. Imagine Stephen 2 years after the trial. He loses his high-paying job, or his former spouse moves to a different state. The final judgment that felt so permanent suddenly becomes a document in need of modification. The historical trend in 2026 is toward a system of continuous oversight. The court remains a presence in the life of the family until the children reach the age of majority, or the alimony duration expires. This creates a historical reality for men where the end of the divorce is not the end of the legal relationship, but the beginning of a new phase of court-monitored interactions. As we look at the evolution of the trial and the final decree, we see a system that has moved toward standardization. The potential outcomes are increasingly governed by formulas and guidelines, yet the human element of the individual judge remains the most significant variable. For a man navigating this in 2026, the trial is the ultimate test of his documentation, his discipline, and his legal strategy. It is the moment where the years of preparation meet the reality of the law. But once the gavel falls and the courtroom clears, a new question emerges. How do you actually live under these orders? How does the law handle enforcement when one party refuses to follow the decree? And most importantly, how has the historical study of divorce for men influenced the way a man rebuilds his life in the years that follow? In our final part, Part 10, we are going to dive into the aftermath and the future of matrimonial law. We will look at the history of contempt of court, the rise of the men's rights movement in legal reform, and the emerging 2026 trends in prenuptial agreements that are changing the way men enter marriage in the first place. The final chapter is about the world you step into after the legal war is over. The entry of a final judgment is often mistaken for the finish line, but in the historical study of American family law, it is frequently just the beginning of a new legal phase known as the post-decree era. To understand the potential outcomes for a man like Stephen as he moves into the year 2026, we must examine the mechanisms of enforcement and the evolution of the contempt power. Historically, the American legal system granted judges the power of the gavel to ensure orders were followed, but the 20th century saw a massive expansion of these powers to handle the increasing volume of non-compliance in domestic cases. If Stephen's former spouse refuses to turn over a specific asset or interferes with his court-ordered parenting time, Stephen must engage in what is known as a motion for contempt or an order to show cause. In the 2026 legal landscape, the process of enforcement follows a strict historical precedent. There is a distinction between civil contempt and criminal contempt. Civil contempt is remedial. Its goal is to coerce compliance. For example, if Stephen is owed a $50,000 equalization payment that remains unpaid, the court can order the spouse to be jailed until the payment is made. A legal concept often referred to as holding the keys to one's own cell. Criminal contempt, however, is punitive. It is designed to punish a party for a past violation of the court's dignity. The historical trend in 2026 shows that while judges are hesitant to use the jail cell for financial disputes, they are increasingly willing to use financial sanctions, such as awarding Stephen his attorney fees, to punish non-compliance. Beyond enforcement, we must analyze the historical shift in the modification of orders. The American legal system has long recognized that life does not stand still. The doctrine of a material change in circumstances allows a man to return to court to adjust his obligations or his rights. Imagine Stephen in late 2026. He receives a significant promotion, or conversely, the tech sector faces a downturn and he is laid off. Historically, child support and alimony were rigid, but the modern trend is toward a more fluid, math-based adjustment. Under the income shares model used in most states, a change in Stephen's income, or the other parent's income, can trigger a recalculation. However, the historical data warns that these modifications are rarely retroactive. If Stephen waits 6 months to file for a reduction after losing his job, the law historically bars the judge from reducing the arrears that accumulated during those 6 months. This step-by-step requirement for immediate filing is one of the most critical lessons in the history of domestic litigation. As we look at the broader historical arc, we must address the rise of the men's rights and shared parenting movements that have fundamentally reshaped the 2026 legal environment. In the 1990s, these movements were grassroots and often marginalized. However, by 2026, organizations like the National Parents Organization have successfully lobbied for legislative changes in dozens of states. This historical trend moved the needle from a maternal preference system to one where the 50-50 presumption we discussed in Part 5 is becoming the standard. Case studies from states like Kentucky and Florida show that after these laws were passed, the volume of high-conflict litigation actually decreased, as the potential outcomes became more predictable. This is a seismic shift in American legal history, the move from a system that incentivized conflict to one that mandates cooperation through statutory presets. This leads us to the most significant development for men entering the 2026 landscape: the evolution of the prenuptial and postnuptial agreement. Historically, prenups were viewed with suspicion by the courts, often seen as encouraging divorce. But the landmark 1970 case of Posner v. Posner in Florida changed the trajectory of American law, ruling that these agreements were valid contracts if entered into fairly. In 2026, the prenuptial agreement has moved from a tool for the ultra-wealthy to a standard protective measure for the modern professional. The 2026 trend in prenups involves what are known as lifestyle clauses and sunset clauses. A man in 2026 might include a non-disparagement clause that prevents either party from posting negative content about the other on social media. He might include an infidelity clause, though the legal enforceability of these varies by state, or a sunset clause that causes the agreement to expire after 20 years of marriage. The historical data indicates that men who enter marriages with these agreements experience a radically different divorce process. The discovery phase is truncated, the property division is predetermined, and the potential outcomes for alimony are capped. The legal history of the 21st century is the history of men using contract law to opt out of the default statutory rules of the state. But what about the psychological aftermath? The historical study of divorce for men often ignores the long-term socioeconomic impact. Data from 2026 shows that men often experience a sharper decline in their social network and mental health following a divorce, even if they fare better financially than in decades past. The legal system has begun to respond to this by integrating mandatory co-parenting classes and recommending therapeutic resources. The history of the court has moved from a cold arbiter of property to a quasi-social work entity that recognizes the human cost of family dissolution. As we conclude this 10-part masterclass, we look back at the journey we have taken. We have moved from the era of coverture, where a man held all the power and all the liability, through the theater of the fault-based era, into the administrative clinicalism of the no-fault revolution. We have seen how the tender years doctrine was dismantled and how the 2026 landscape is defined by 50-50 presumptions, forensic data, and the loss of alimony tax deductions. The American legal history of divorce for men is a story of a pendulum swinging from one extreme to another, eventually settling on a system that prizes mathematical equity over moral judgment. For the man in 2026, knowledge of this history is the ultimate defense. The potential outcomes of your case are not just a matter of luck. They are the result of how your specific facts interact with these centuries-old precedents. Understanding that the judge is a product of this history, that the laws are constantly being rewritten by advocacy groups, and that the paper trail is your most honest witness, allows you to navigate the process with clarity rather than fear. The battle for the future is won by those who understand the past. You have now completed the deep dive into the historical mechanics of the American divorce system, but the legal world never stops evolving. As we move further into 2026, new technologies like artificial intelligence in judicial decision-making and the rise of decentralized assets are already creating the next chapter of this history. This masterclass has given you the foundation, but the landscape is shifting beneath our feet. The question now is not just how to survive the system, but how to master the new rules of engagement. In our next deep dive series, we will explore the cutting-edge frontier of digital asset protection and the rise of AI-driven legal strategy. We will analyze how the 2026 courts are handling Bitcoin, NFTs, and virtual real estate in the marital estate. The history of the future is being written right now, and you need to be ready for the next evolution of the law. Stay tuned as we dive into the high-tech financial war of the late 2020s.